Pro-XRP lawyer John Deaton has shared 3 hints on the potential details of his upcoming big announcement. By the way, the latest attempt from Binance to convince a U.S. court to dismiss its ongoing case with the SEC taps into a recent ruling in favor of Ripple. Moreover, what prompted the SEC chair to disregard the court's decisions? Finally, was the SEC appeal against Ripple's ruling as a result of a threat? Stick with me till the end to find out more. If this sounds like something of much interest to you, be sure to check out this new video starting now. Hello everyone and welcome to our channel, where we talk about the latest updates on XRP and the cryptocurrency world in general. If this is your first time watching one of our videos, we happily send you a special welcome. We invite you to hit on the notification bell so you never miss another video. We are announcing that this channel has a giveaway of 200 XRP. To stand the chance of participating, all you have to do is simply subscribe to the channel, like this video and comment with the hashtag XRP, and the winner will be announced on the 30th of September. Attorney John Deaton, the founder of Crypto-Law.us, has given 3 hints regarding his highly anticipated big announcement, which he intends to share. For context, Deaton tweeted earlier this week that if everything works out, he will be making a big announcement on September 22nd. The tweet left XRP community members guessing, with many asking Attorney Deaton to provide hints that could help them prepare for the so-called big announcement. Notably, Deaton finally shared 3 hints after Jungle Inc. 2.0, a prominent XRP enthusiast, requested a clue regarding the announcement. John Deaton, can we get a hint on what the possible announcement tomorrow may be? The XRP enthusiast quizzed. Responding, the pro-XRP lawyer noted that the big announcement revolves around a picture he attached to the tweet, the XRP ledger, or the Ethereum ICO saga. Deaton's first clue came as a photograph of him critically examining some documents. Although the contents of the docs were not visible from the picture, XRP enthusiasts speculate that the docs could relate to the ongoing SEC versus Ripple lawsuit. If true, then there is a likelihood that Deaton could be sharing a significant development regarding the lawsuit. According to John Deaton, the most controversial subject in the digital currency ecosystem at this time is the enforcement crackdown carried out by the United States Securities and Exchange Commission on industry pioneer and advisor Steven Narioff. His first announcement to his more than 296.8K followers is that he will bring Narioff to crypto law to uncover the very truth about his indictment, coercion by the regulator, and why the case was finally dropped despite a damning indictment at the time. Having given hints on what to expect ahead of the live show that he concluded a few minutes ago, John Deaton noted that his announcement will also be centered around the XRPL. In letting the cat out of the bag, Deaton said he is joining Spend the Bits, a payment protocol built atop the XRP ledger, as both an investor and its chief legal officer. The industry advocate noted that he believed in the visions of the protocol and in the work of the founder, Jay, who he noted can help fulfill the dreams of Satoshi Nakamoto in our world today. The last announcement centered on the comprehensive memoir he has been working on since March 2020, right before the whole Ripple Labs Inc. legal brawl with the Securities and Exchange Commission came into effect. Per his hint, the book will cover basically the most critical subjects in the dynamic world of today, including race and abuse, and he urged netizens to watch out for the masterpiece. Notably, Attorney Deaton is deeply immersed in the lawsuit, representing thousands of XRP holders in the capacity of amicus curiae. Deaton's involvement in the lawsuit contributed to giving Ripple a partial victory against the SEC. Please, do not forget to subscribe to our channel and also hit that notification bell to be the first person to get more updates about the latest happenings as regards to XRP. Binance and its related entities, sued by the United States Securities and Exchange Commission, have filed a motion to dismiss charges brought against them by the regulatory body. Notably, the latest motion seeks to leverage a recent court ruling in Ripple's favor, which found that secondary market XRP sales did not constitute securities transactions. The reference to Ripple's court ruling comes within a section where Binance, in its defense, argues that the SEC's reliance on past initial coin offerings cases is misplaced. Binance points out several cases in which courts left open the possibility that tokens sold by investors did not constitute securities transactions. The exchange referenced SEC lawsuits against projects such as Telegram, Ken, Terra, and LBRY. However, Binance particularly references Ripple's case handled by Judge Torres as the only court to address transactions analogous to those that allegedly occurred on the Binance US platform. Binance then alluded to the court finding that secondary market XRP sales were not investment contracts. Given such a ruling, Binance claims that crypto trading on its platform could not be classified by the SEC as securities transactions. A section of Binance's Memorandum of Law in motion to dismiss reads, "The undisputed facts in the Ripple case showed no relevant relationship between the parties to the sale that could transform the sale of a digital asset into the sale of an investment contract." Beyond tapping into Ripple's win, Binance also strongly argues that the SEC's lawsuit represents an overreach. The filing quotes comments from SEC Chairman Gary Gensler in May 2021, in which he conceded that the crypto scene did not have a regulatory framework for the SEC or the CFTC to properly oversee the industry. Since the SEC chair's concession, Congress has not adopted new legislation to expand the SEC's authority in the digital asset space, Binance claims. The filing also notes that the SEC is trying to achieve by litigation what it lacks by legislation, thus going beyond the regulatory powers Congress has granted it. It remains to be seen whether the court applies Ripple's court ruling, which the SEC has already appealed to Binance's ongoing lawsuit. However, the latest development underlines the role of precedent in the legislative field and how Ripple's win could potentially be leveraged to provide further regulatory clarity to the U.S. cryptocurrency industry. Furthermore, Ripple's chief legal officer, Stuart Alderoty, has expressed concern about recent statements made by Gary Gensler, the United States Securities and Exchange Commission chairman. The Ripple CLO voiced his concerns following Gensler's recent interview on Bloomberg TV. During the interview, Gensler highlighted the benefits of implementing existing securities laws in the crypto industry. According to Gensler, applying securities laws to crypto would protect investors from fraud and manipulation. With the securities law, investors still benefit from disclosure and they get to choose based on that disclosure, Gensler remarked. Investors benefit from laws against fraud and manipulations, as well as other conflicts in the market. Following Gensler's assertion, Bloomberg's Francine Lacroix asked the SEC chair whether the courts could change his stance regarding crypto. In response, Gensler said he wished the court would help bring compliance to crypto sooner. Expectedly, Gensler's remarks stirred reactions among crypto enthusiasts, including Alderoty. Per Alderoty, it is shocking that Gensler, whom he referred to as an unelected bureaucrat, has admitted that he will not respect court's decisions. Notably, Alderoty could be suggesting that Gensler is not planning to respect the court's ruling in the Ripple case. Recall that the SEC suffered a major defeat in its lawsuit against Ripple. The SEC alleged that Ripple violated federal laws by offering and selling XRP as an unregistered security. However, the court rejected the claim, ruling that XRP itself is not a security. The court also ruled that most of Ripple's XRP-related transactions, which the SEC alleged to be securities, are not. The SEC has expressed dissatisfaction with the ruling and has asked the court to certify an interlocutory appeal to allow it to challenge the decision on Ripple's programmatic sales and other distributions. If the court approves the request, the SEC would also request permission for an interlocutory appeal from the Second Circuit. However, if the court denies the request, the SEC will have to wait until all pending issues in the lawsuit have been resolved before it can file a full appeal. In this scenario, the SEC could file a full appeal toward the end of next year. Now to the big question of the day, was the SEC appeal against Ripple's ruling as a result of a threat? Please, do not forget to subscribe to our channel and also hit that notification bell to be the first person to get more updates about the latest happenings as regards to XRP. Mark Fagel, a former official of the Securities and Exchange Commission, has revealed the major reason why the SEC requested permission to certify an interlocutory appeal in the Ripple case. On Friday, pro-XRP lawyer Bill Morgan reported that Binance has filed a memorandum of law in support of its motion to dismiss the SEC case. The exchange's lawyers highlighted the Ripple ruling as a legal precedent to push for the dismissal of the SEC's complaint. Notably, Binance argued that the U.S. District Court for the Southern District of New York, which presided over the Ripple case, found that Ripple's programmatic sales of XRP were blind bid/ask transactions, thus, they do not constitute investment contracts. Commenting on the development, Attorney Morgan pointed out that the SEC foresaw other crypto-related companies like Binance and Coinbase using the Ripple ruling to support their defense. He asked whether Binance's recent argument was the reason why the SEC sought an interlocutory appeal on Judge Torres' decision. In response, Fagel, an expert in securities litigation, answered in the affirmative. "Yes, that's why they had to appeal," said Fagel. According to favour, the SEC seeks to appeal the Ripple ruling because the decision threatens its broader program against exchanges. He noted that the SEC could have tried to argue around the ruling if the concerns involved only issuers of securities-related assets and tokens. It is worth noting that the SEC shares a similar concern. In its effort to have its interlocutory appeals certified, the SEC argued that the court's ruling on programmatic sales could substantially impact its pending litigations against crypto exchanges Coinbase and Binance. Interestingly, it did not take long before Binance referred to the Ripple ruling as a legal precedent to dismiss the SEC's complaint. The court has yet to issue a ruling on the SEC's request to certify an interlocutory appeal. Meanwhile, crypto community enthusiasts have been speculating on the outcome of the ruling. As reported earlier, Crypto-Law.us founder John Deaton speculated that the court would deny the SEC's request to certify its interlocutory appeal. Per Deaton, after the court denies the request, the regulator will have to wait until the end of next year to file a full appeal challenging the ruling. So we come to the end of this video. If you enjoyed it, like the video and don't forget to subscribe. This really helps me with the YouTube algorithm. Also share this video to as many people as possible. Let's get this news everywhere. If you are a true cryptocurrency fan, don't miss any of our content. See you tomorrow to talk about the latest news that concerns us all as a community.